Someone make it make sense.
Probably a couple.
Welcome, 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 one and all. Happy to see you guys. You guys, so much is happening in the world of trials today. Oh my God, I have so much in store for you guys. I'm super excited. I was just wrapping up some of my lessons here, and you know, kids, you know how kids be, right? Anyway, just got it done, got everybody situated, and it is all good. Welcome, Meg. Welcome, James, official, Franks. Welcome, Abby. Love it. Love that everybody popping in the chat so far has got their own custom command. That's what we like to see. Y'all, so we've got, we've got some new filings here for Idaho, obviously, but we've got more than that. I've got a special treat for you guys, dude, for the Lori's Inner Circle. I'm trying to decide if I want to say what it is or not, or let y'all be surprised. But God willing, if I can get this to finish uploading, we will actually redirect into that. It'll be something that we will definitely carry over into tomorrow prior to the court going live for Arizona. So basically the way that's going to work is, there's like a 3-hour time difference, at least for me, and then there's a half an hour delay. And the schedule is such that court opens at 10:30, right? But then the jury instructions, as in Judge Boreski reading them to the jury, that's scheduled for 11. Then they have lunch at 12. And then at 1 o'clock, that's when they're supposed to begin closing arguments. Did I say opening statements? I meant closing arguments. And so that would be 4 o'clock my time, but then there's a half an hour delay, so that's 4:30. So I'm thinking what we will do is, instead of starting with the court and then having the hour lunch break, I'm thinking what we will do is do it all, like essentially start the jury instructions around when they go to lunch. So that way we can do it all in one fell swoop, with the jury instructions going seamlessly into closing arguments. And then prior to that, we can be doing our Lori's Inner Circle, because I have so much stuff for this. It's insane. And then we will be on verdict watch. Tomorrow evening, we have our members only trivia night. So you guys have probably heard much about this. That will be tomorrow night. I have it scheduled for 10 o'clock. However, if we're still on verdict watch, that will get pushed back, because again, I don't know what the rules are. And if they let the jury deliberate up to 7 or 8 o'clock or whatever, then that, again, there's a 3-hour time difference and a half an hour delay. So we're just going to play it by ear, but I have it slated for 10 o'clock, hoping that we can go into verdict watch and then hopefully get a verdict and then go into the members only live stream. So there's a lot going on. And I'm just making sure that this is set up. Okay. Cool. So let me just make sure this is set up to redirect. But I hope you guys had a wonderful Easter and a great weekend. It was nice and warm here today. Feels like summer. So let me just get this going here. All right. And yeah, this should be good to go. So it's really funny because I just refreshed this, and I think it was yesterday, I believe. Was it yesterday? This morning? These just popped up basically here in Idaho for Bryan Kohberger. So that's why it's always worth checking, and then triple checking, and then quadruple checking. That works out for you, doesn't it, Official? That is really funny. Official says there was a whole flat earth conspiracy fight in one of Lori's chats because of the time zones. I don't know how the time zones make a difference, but that is funny. That is pretty funny. For free, what is for free? Free squirrel hugs for all, though. Okay, so y'all are definitely going to want to make sure you make it for the members only live, and there's another surprise that's going to be for members as well tomorrow. So, all right, so let's start out. First things first. All right. So first we have, oh my God, this is 17 pages. Okay. Order memorializing oral rulings on motions in limine. Introduction. Before the court are several motions in limine. Should I read it with an accent? No, I'm just kidding. Filed by both the documents for free. Of course, they're free. The defendant and the state. Oral argument on motions was held April 9th. On several motions, the court rendered oral rulings from the bench. This order serves to memorialize those oral rulings together with the findings the court made during the hearing. This is a great idea. And I feel like we don't ever really see this. Like, okay, I guess there's like subsequent rulings that come out, but like, I do like how clear this is, that this is to memorialize the oral rulings. Like this is laid out very nicely, and I enjoy that. Okay, standards. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And of course, as you guys should know by now, that is Rule 401. All relevant evidence is admissible except as otherwise provided by these rules. So that there's Rule 402. Look at this, going through it all. Then we get to Rule 403. Y'all know this one so well by now, I'm sure. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. So I like to think of this as the balancing test, right? Probative versus prejudicial, confusing the issues, waste of time, or cumulative. That's an easy way to think of that one. Okay. On discretionary matters, the trial court must, 1, correctly perceive the issue as one of discretion, 2, act within the outer boundaries of its discretion, 3, act consistently with the legal standards applicable to the specific choices available to it, and 4, reach its decision by the exercise of reason. Welcome, Heather. Wait, I'm your only twin flame, Heather. Are you cheating on me with other twin flames? What did we discuss the last couple live streams, Official? I love that name too, Official. It's like, yep. There it is. It's official that you are that person. Okay, and I'm just making sure I've got the surprise set up for you guys. Y'all are going to lose your minds. Oh my God, oh my God, oh my God. Okay, so, all right, analysis. Defendant's motion in limine number 1. So this is the inflammatory evidence. Defendant moves under Idaho Rules of Evidence 403 to prevent the state from introducing testimony and evidence that is, quote, exceptionally inflammatory, arguing it is irrelevant and or unfairly prejudicial. The court finds this motion is premature. As with any potentially prejudicial evidence, the court must first consider whether it is relevant and material as to an issue of fact under Idaho Rules of Evidence 401 before assessing whether its probative value is substantially outweighed by the danger of unfair prejudice. And there's some case law there. At this point, defendant has not identified what specific evidence he wants kept out or otherwise defined exceptionally inflammatory. Okay. Issuing an order as requested by defendant would lack any substance. It would simply require the state to abide by evidentiary rules and prosecutor. Okay, so I remember this from the hearing. This is where he's like, look, they have to follow the rules anyway, right? The court finds it unnecessary and therefore denies the motion. However, this was a particularly horrific murder and there will be exceptionally graphic depictions of the victims and the crime scene. And one of the things that I said was, I was like, I bet this is going to go towards a cumulative crime scene photos. We see this in every case. Prior to seeking the admission of this evidence, the state is required to provide copies to the defendant. If the defendant believes the evidence is cumulative, unnecessary, or otherwise prejudicial, he can seek to take the matter up outside the presence of the jury. I mean, that's fair. That's fair because they were not specific. I think it's fair. All right. Next up, use of the term murder. Murder most foul. Defendant seeks to prohibit the use of the words murder, murderer, murdered, murder weapon, and similar forms of the word murder as applied to the defendant. And again, defendant seeks an order requiring the state to abide by it. So again, it's very similar. It's unnecessary. Remember, he was like, I give you a stern warning. Do not argue apart from closing or I will have you beheaded, essentially is what he said. I'm paraphrasing. The state acknowledges it would be improper to refer to the defendant as murderer other than stating what the allegations are and has no plans to do so. We'll see if they abide by this, right? What do you guys think? Let me know. Do you think the state will try to cheat this one here? I mean, I, for one, feel like this is extremely optimistic of the court. but okay. So next we have the defendant's motion in limine number 4, use of the terms psychopath or sociopath. Defendant moves to exclude any reference to these terms, right? Of course. The state does not intend to use these terms at trial. Indeed, the terms are irrelevant given the lack of evidence the defendant has been diagnosed with a personality disorder. I mean, and this bothered me during the hearing as well, right? Everybody knows damn well, right, that the defendant didn't make this motion in limine because they're like referencing a diagnosis. The example I gave is akin to saying monster, right? We hear this all the time. He's a monster. They're using those terms like that, right? Not like there's an actual diagnosis. So I find this a bit like, what's the word I'm looking for? Plausible deniability, that like, oh, well, yeah, we're taking it literally when that's not what they mean. But anyway, their use would also be highly prejudicial. Thus, the state is not to use these terms at the guilt phase of the trial. However, if the state believes the door has been open to allow such use of the terms, it shall raise the matter in advance outside the presence of the jury. So the motion is granted. So he granted the defense motion. You know what's so funny? If this was Judge Bev, she would have denied it because, like, for example, like these ones, right? Denied as unnecessary. This is actually granted, which is interesting because he could have said denied because it's unnecessary because they shouldn't do it anyway. But he actually granted it. So that's interesting. State's motion in limine improper death penalty comments under rules 401 and 403 to preclude defense counsel from making what it calls improper comments about the death penalty, specifically that the state is attempting to kill, and that's in scare quotes, defendant, which defendant counsel has stated in past hearings. Defendant stipulates to using phrases that comport with existing language in statute and jury instruction. Again, the court is unwilling to enter an order requiring defense counsel to act professionally and comply with existing rules. As the defense counsel recognizes, any such statements would be argumentative and improper. The court trusts defense counsel will comport themselves accordingly, and it's denied as unnecessary. Again, welcome back again, Tony, and need some Z's as well. Right, exactly. And I have no idea what's up with this thing, that the Trump kid thing. I don't even know what that is. I'm out of the loop. Derble, Meg, welcome, Happy Annie. I'm seeing who else I've missed here. Bryan volunteered at Special Olympics. Yeah, that came out in the hearing. It's funny you guys are mentioning the Olympics because in our members only trivia night, there's going to be a question about the Olympics there. Thank you, Heather. I'm your only twin flame. The others are also twin flames with others. Excellent. Well said. Yeah. So need some Z's agrees here. The state will 100% try to use all things they claim they have no plan to. Yeah. Yeah. That's my take on it for sure. Yeah. I remember that one too, Heather. So for anyone who's just now getting here, I have a big, huge surprise in store for you guys regarding the next live stream with the Chad and Lori, and y'all get ready. It's a big deal. I'm excited. Okay. And again, I said at the beginning of the live stream, I'm debating whether or not to. I'm so excited. I'm like, should I tell you guys or should it be a surprise? I don't know. Anyway. All right. So then unnoticed 404B evidence. So this was very, very vague. It didn't even, I'm not even going to read all this because it was just vague. And this was separate from the other 404B, which is the traffic stop. So, okay. Improper testimony. So this is the Mittelman. Okay. IGG, right. Both parties moved to exclude evidence of law enforcement. Okay. So just the tip, right? We're in just the tip territory. Official says, don't tell us. Okay. I won't. IGG testing for this case, but for entirely different reasons. Given the parties' agreement to not present any IGG evidence, those reasons need not be discussed. So they're just saying it's just the tip. Just the tip, guys. There you go. Tony's quoting Judge Bev. I'll allow it. Y'all have all seen Judge Bev's Barbie doll, right? Because that's fucking hilarious. Welcome, Northwest, dude. Get excited. I have a big present for you. I know you're going to be especially excited for the next live stream. Northwest is like a Chad and Lori scholar, as it were. Okay. Conditions as aggravator. Defendant moves to prevent the state from using Northwest. Oh my God, Northwest, y'all. My brain. I've doing so many things today. Using defendant's diagnosis of autism spectrum disorder. Yes. And the characteristics of his ASD as an aggravating factor at the penalty phase of the trial. The state responds it has no plans to use such evidence, but it will argue against and rebut defendant's diagnosis to the extent he relies upon it as a mitigating factor. Footnote 4. To the extent defendant introduces evidence of his ASD as a mitigating factor, the state is allowed to confront that evidence so the jury can afford it appropriate weight. It cannot, however, attach an aggravator label to it. Okay. Come for the weather. Interesting. Oh, you like the command? Sweet. Montana. Wow. Do you have horses? Officials dollhouse arrives in June. Are you going to have blow up dolls as well for that? They're on back order at Etsy. You know what else you can get on eBay though, right? You guys know what I'm talking about. I think eBay, that says it all, doesn't it? No horses. That's a bummer. I'm a huge horse person. Well, we've talked about this at length, so I feel like I don't want to be redundant, you know? We've talked so much about just the tip, and I feel like if I'd be happy to share my thoughts, but I feel like you guys have heard them before as far as how that's going to go. I think it's ridiculous. I think that it's like a game of chicken. It reminds me a lot of in the Murdaugh trial with like Cousin Eddie. And also with, there was another dude, the dude who messed up the blood on the shirt or whatever the fuck it was. Because, well, there wasn't blood on the shirt, but like what was his name? Forget his name. There was a motion to eliminate. He wasn't talked about trial. Cousin Eddie's a better example. Both sides were trying to bait the other side to open the door. I think it's one of those situations because there's no way they can do just the tip. There's just no way. So they're saying just the tip. There's no way it's going to be just the tip. And if they open the door, then the defense can have a field day. That's right. Put her in the pool with a tiny waterfall and watch her grow. Yep. By the way, Meg showed us a house, sent a video on YouTube with a house with a legit huge ass waterfall. It was amazing. That's really funny. That seems a bit, I don't know. Oh, the doll, you're saying the dollhouse. I was thinking if it was if there's blow up dolls, then the knife, you might not get your bang for your buck with that one, right? Make sure the knife isn't going to pop the plastic. I mean, the story of the tip, there's no way they can say how the tip happened without IgG. It's impossible. Impossible for a plain yellow pumpkin. Sorry, let me change it. Impossible for a tip about IgG to not open the door. I don't know. Anyway, anyone ever agree to it? Agree to what specifically? The buccal swab's irrelevant. That's completely irrelevant. That's something that's completely different. Buccal swab's completely, fine. That's not what we're talking about. When they try to tell the story of the investigation, how did they get to this person, right? That's like every investigation is like, how did we get to this person? They've got one thing, and that's the IgG. So, she's agreed to just the tip. I'll go back and read it again. She's agreed to just the tip because it's smart, right? This is strategy. This is strategy. It's like giving them just enough rope to where they can, hang themselves, as it were, right? But it's like such a small amount of rope that the state, I don't know, the state is in a position where they have two options. They either don't explain how they got to Bryan Kohberger, and then you're looking at an acquittal, right? It doesn't matter if the DNA matches. If they can't explain how they got to him, the jury's not going to buy that. I can't imagine for the life of me, right? It's gonna be like, it's different than like other cases where there's a family member or somebody, you know what I mean? Like, this is just not so. Yeah. So the state has the two. Either they fought so hard to keep the IGG out, right? And the defense has fought so hard to get the IGG in and to get it, to make it public and for the transparency and for it to come out. And this has been the whole thing. We've talked about this so much, and so the state has the option of either just not explaining how they got to him, right? Or they have to explain how they got to him, but trying to do it in a way that is not going to open the door to IGG. So that's where you get just the tip. So let me read this again. So given the parties' agreement to not present any IGG evidence. So remember, again, like the defense initially seemed like they wanted to put this in at trial, right? We've talked about this at length. But now that the state, right, is wanting to do just the tip, now the defense is like, okay, fine. We're not going to present any. Why? My opinion, I think they want the state to open the door on themselves. Given the parties' agreement to not present any IG evidence, those reasons need not be discussed given the bottom line agreement and the court grants the motions. So the other thing is this, had the defense not been fighting so hard for the IG this whole time, they wouldn't be in this position where they have this strategic option, because this wouldn't even be a thing, right? We're only in just the tip territory because the defense fought so hard. And I think this is exactly what they wanted, right? They would rather it not come in if it points to the defendant at all, right? Like, it's win-win for them. It's win-win for them. Because if the state doesn't get into it, then it doesn't point to him. And again, I think for a jury, they're going to have a hard time convicting, right? I mean, I don't think there's ever been, I've never heard of a case where they can't explain how they got to the defendant in some way. How they actually got a name of a person or whatever to even look into in the first place, right? So either the state is keeps it really minimal, but then it's probably not going to be good. The jury's probably not going to like that, right? Or the state gives the jury a little bit more than just the tip. Let's just say just the tip and then some. And then the defense has the choice, right? It's going to be the ball. It gives them every advantage because then they can decide how they want to go with it. So the state has indicated it will present evidence through Detective Brett Payne that the defendant's name was revealed to law enforcement through a tip. To avoid issues at trial, the court advises the parties to arrive at a mutually agreeable narrative about how the tip came about. Okay, footnote 3. If agreement cannot be reached, the parties are to submit to the court their proposed narratives prior to trial, and the court will decide how it will be presented. Interesting. A narrative. I see why he's doing this, right? To avoid issues at trial. But I don't know. The parties are also directed to jointly craft a jury instruction advising the jurors not to concern themselves with the source or nature of the tip. This is just so Karen Reed, isn't it? Like with the third party. Like, you can tell them not to concern themselves. If you don't give them more, they're going to be like, where did it come from? I mean, that's just literally what's going to happen. If you're like, oh, it's just a tip. And that's just the tip, right? People are going to have questions, I would think, and they're going to want more. But who cares? No big deal. The jury wants more. Anyway, yeah, the buckle swab had nothing to do with the IG. Nothing to do with it. Yep. Absolutely nothing to do with it. Completely. The buckle swab is not, it's like the least important thing in my view. Right. She didn't agree. Right. Well, it's the court it's the court's choice about the narrative, right? The court advises the parties to arrive at a mutually agreeable narrative about how the tip came about. Yeah, Heather agrees they want the state to open the door. Yep, that's what I think. That is what I think. That is what I think. Right, exactly. I agree. I don't see how the state can't open the door. Absolutely. Couldn't agree more. Welcome back, Christina Vada. Yeah, just the tip. Oh yeah, just the tip, just the tip. Classic Heather with the all caps. I'm just catching up on the chat here. And the other thing is this, like, the other thing is this, that it's hard to fully appreciate this whole thing if you haven't, I don't know, followed this case like an insane person, because I don't even know how else to word it, because, like, there's just so much history with this, and the IgG has just been such a whole thing. And there's been, it's understandable, right? There's 50 bazillion court filings. There's been a bazillion hearings. You know what I mean? It's like, but if you miss something, then, I don't know. Hopefully I'm making sense sort of there. So, okay. Let's see. Did I read the whole footnote? Where am I? In space and time. Okay. Yes. Footnote 3. Correct. So if they don't agree, the parties can submit to the court their proposed narratives prior to trial, and the court will decide how it will be presented. Well, they're not going to agree. I can tell you that much. It'll be really interesting. I hope we get to learn those, although I feel like probably we won't. The parties are also directed to jointly craft a jury. All right, I already read this part. Yeah, this is a problem. The IgG is so important in this case that I don't see how, like, the defense is going to be like, are you kidding me? A jury instruction not to concern themselves with the nature of the tip? Are you fucking kidding me? No way. No way. Nope. Not enough. That is, I see why he's doing this. I think he can see that this could blow everything up, right? So, I mean, 100%, Heather. Yeah, they won't agree. Okay, so we were here, though. We were talking about the mitigating factor. We read footnote 4. Okay, so despite the state's concession, the court is concerned with the breadth of defendant's motion. He's not only seeking to preclude the state from referencing his ASD diagnosis and aggravator, but any symptom of ASD. Given the broad nature of ASD symptoms, the court foresees an issue potentially rising at trial, whereby the state makes a reference to an action taken by the defendant that the defendant contends is a symptom of ASD. And they talked about this in the hearing, and I thought it was interesting. That evidence is not currently before the court. Welcome, Kimmy. Thus, at this point, the court will preclude the state from arguing or presenting evidence of defendant's ASD diagnosis as an aggravator, but it is not in a position to rule on whether any particular evidence must be excluded on grounds that it evidences a symptom of ASD. The motion is therefore granted in part only. I'm so glad he put all this in writing. You know what I mean? Like, this is great. Has written this in an order. Are you referencing the IgG about the jury instruction? Maybe. I mean, yeah, like, there is plenty in here that strains credulity. However, I'm glad it's in writing, right? Because he was also very hard to hear at the hearing. And this also just makes it a lot easier to fully, having it in writing is just so important, right? So, yeah. So even if whether we disagree or agree with what a judge decides, I'm just glad we have it in writing either way. Okay, state's motion in limine, alternative perpetrator evidence. The state seeks an order prohibiting defendant from offering alternate perpetrator evidence without first making a showing that such evidence is relevant and admissible under Idaho Rules of Evidence 401 and 403. These rules govern the standard of admissibility for alternate perpetrator evidence. Mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of Idaho Rules of Evidence 403. Again, there's an interesting kind of, we see this in the case. Anyway, defendant acknowledges his burden under Meister, but argues the state's motion is premature. According to the defendant, this case is full of alternate perpetrators, and he intends to produce offers of proof as to alternate perpetrators. Funny that these are in scare quotes. While defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial to do so, particularly if defendant intends to submit multiple offers of proof. Laying foundation for the admission of evidence will likely take a significant amount of time. Long, a significant amount of time. After all, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. So remember, you know how it's like third-party culprit in Massachusetts? In Idaho, the comparable defense, right, is alternative perpetrator, right? So yeah. To avoid undue delay at trial, a defendant must present the offer or offers of proof no later than May 14th, 2025. Oh, so the matter can be addressed at the pretrial conference. Footnote 5. Footnote 5. The scope of the preclusive effect of this ruling includes suggesting that specific individuals looked at and cleared by law enforcement are alternate perpetrators without first complying with a showing required by this order. Okay. The court will reserve ruling on the motion. Okay. Next up, we have statistical analysis. Defendant moves in limine to exclude any misleading comments about the meaning of a likelihood ratio for DNA purposes. Specifically, defendant seeks to avoid attempts to define likelihood ratio through a comparison to the world population. Footnote 6. Defendant's motion is directed toward the prosecutor's questioning of a lab analyst at the grand jury proceedings. There, the analyst testified that her DNA testing showed the profile developed from the knife sheath was 5.37 octillion times more likely to be seen if the defendant was the source than if an unrelated individual randomly selected from the general population is the source. In an attempt to clarify this result, the prosecutor asked whether this meant that if there were 1.37 octillion people, that it meant it would be Bryan Kohberger is one out of that many octillion. The lab analyst explained why this comparison is not a proper way to view a likelihood ratio. Okay. The state agrees that this type of comparison is inappropriate. The court grants the defendant's motion, okay, insofar as it applies to the question asked by the prosecutor at the grand jury proceedings, which both sides agree was not proper. However, the court will not dictate how the question is to be asked at trial. Interesting. If defendant believes there is a similar misrepresentation as to likelihood ratio at trial, he can object at that time. Okay. I don't think we've gotten to that part yet, but that is crazy. If he says there was a preliminary hearing, did I miss that? I mean, I'm reading so fast, but like, yeah, and we definitely haven't seen a date for the arrest, but that is wild because, yeah, how can you get that wrong? That's crazy. Okay, so next we have the inconclusive data. Defendant moves to limit expert testimony about the Idaho State Police Forensic Lab statistical analysis of a swab taken from the fingernail clippings of Madison Mogan. The testing revealed a likelihood ratio in the inconclusive range as to whether the defendant was a potential contributor to the DNA mixture. During her grand jury testimony, the lab analyst, Jade Miller, testified that inconclusive meant she was unable to say one way or another whether or not defendant is included in the mixture. By the way, I really liked, there was I guess not an expert, but in Lori Vallow's trial, there was that lady, oh God, what was her name? She was like, maybe kind of like Asian, and she was the one who enunciated really well. And I really liked how she explained inconclusive. It was one of the best I've heard from a from someone who works for the state, right? I mean, she's in law enforcement. She does the forensics, the DNA or what I wrote what she, she was talking about fingerprints actually, but similar thing, right? With this whole, just like we see with everything, the inconclusive, right? And how they describe it. And the way she described it was, I think, the best I've ever heard in terms of being so neutral and also very clear and precise and actually factually correct. So I think I have that timestamped for that reason. So during her grand jury testimony, okay, yes, we already said this part, right? Unable to say one way or the other whether or not the defendant is included in the mixture. Defendant argues this is misleading language in that it allows for an inference that the defendant might be included, which he asserts is inaccurate. The state indicates it will not offer the results of Q 13.1 as inculpatory evidence. Then why are you offering it? Oh, keep reading. Which defendant agrees renders his motion moot. Right. Why would they be offering it if it's not? I mean, do we need to start with relevance? Anyway. However, if the state changes, hold on, where was footnote 5? Oh yeah, we read that one already. Okay. However, if the state changes course with regard to the evidence, it must first raise the matter with the court outside the presence of the jury so the anticipated testimony regarding the meaning of inconclusive can be discussed. At this time, however, the motion is denied as moot. Moot. All right, next we have Amazon click activity. Couldn't agree. Yeah, couldn't agree more. Yep, they need to correct the record. Absolutely. Yeah, definitely. Definitely need to correct the record on that. Yep. Yep. Okay. Defendant moves to exclude any evidence of defendant's Amazon purchase history or click activity on grounds that it is out of context, incomplete, and unfairly prejudicial. This evidence will be presented by the state through Shane Cox and Michael Douglas, who will testify simply to what the documentary evidence state, all of which was provided to the defendant in discovery, footnote 7. Within this motion, defendant also seeks to exclude testimony by Shane Cox and Michael Douglas on grounds that their expert disclosures were insufficient. That will be addressed in a separate order regarding defendant's motion to exclude vague and undisclosed expert testimony. Well, that makes sense, though. The evidence is highly relevant. A K-bar knife sheath was found lying next to the body of one of the deceased victims, all of whom were stabbed to death. Really? You don't say. Defendant's DNA was found on the knife sheath. Records from an Amazon account registered to defendant's name and email show that a purchase of a K-bar knife and sheath was made from the account approximately 8 months prior to the homicides. 8 months prior to the homicides. Click activity on the same account shows that the customer also viewed pages associated with K-bar style knives at that time. At that time, and in the week following the purchase, viewed pages associated with the shipping progress of the knife and sheath. The product was shipped to Bryan Kohberger at his family address in Pennsylvania. So that's more, this is new information that we didn't have. However, it literally proves nothing because it was a household account, as you guys have heard me talk about and rant about a million times. Welcome, AZ. After the homicides, activity from the same account showed the user navigated pages related to the deletion. The user, sorry, hang on. Has anyone else had a cow about this yet? I mean, the user, what user? They have there is literally, this is the thing. There's literally no way they can say who the user is. The way that they would, when you have a household account like this, the only way to really, well, you can't even say definitively, but the best way to do it would be connected to the device, and Amazon doesn't retain that information. So literally the user, oh my God, it could be anybody in the family. Anyway, the user navigated pages related to the deletion of account activity and a week later viewed pages associated with a K-bar knife and sheath. What? Why would someone do this hang on. If they deleted account activity, then how are they able to view it? First of all. Second of all, if they deleted it, why then would they go view it? And then, like, this doesn't make any sense at all. This doesn't make any sense at all. After the homicides, activity from the same account showed the user, God, I swear, navigated pages related to the deletion of account activity. We don't even know what the account activity is. It could be literally anything. Related to the deletion of account activity? I mean, what if, like, Bryan's parents were buying like some kinky shit, right? Or something embarrassing. And a week later, I viewed the pages associated with the K-bar knife and sheath. There's nothing to say that these are related at all or even the same person. This evidence establishes you gotta be kidding me. Why? Oh no. Oh no. Oh Lord. Oh gosh. I can't even read this. What? I can't. I don't even know, guys. I don't even know. What? I'm so confused. How? What? I'm not reading it. Okay. In addition, there's no basis under you guys can read it, right? It's right here. I'm gonna see if I can highlight it. Dude, I am melting. Heather is correct. Yeah, it shows nothing was deleted. Dude. I was gonna make up an analogy. I don't even have an analogy though. This is beyond. Well, the goat, I have the goat, but Meg hates the goat. So I try not to goat when Meg is here. Nah. I don't even know. Like the 1 + 1 = purple = grape is not even applicable anymore, Heather. We've reached into I don't even know what else, but I'll leave it up to you to come up with something accurate here. Is like what? Okay, keep reading. In addition, there is no basis under rule 403 to exclude the evidence, particularly given how probative it is. Like I'm being punked. Defendant argues it is misleading and prejudicial because it paints an incomplete typo, an incomplete picture of the account activity. Argues it is okay. To this end, defendant provides the declaration of his expert, David Howell, the founder of a firm specializing in inter alia, digital forensics, and digital marketplace analytics. According to Mr. Howell, far more information must be reviewed in order to attribute specific activity to a person or other. Yeah, I've said it before. I'll say it again. If this was not a household account, we would be in a very different situation here. However, we are in a household account where he's got, 2 siblings? Anyway, it's just. Well, the thing is we don't know who the user is. It could be anybody in the family, literally. And not. I mean, we can break down how many problems there are with this, but I might blow up. The user, which user? Navigated pages related to the deletion of account activity. So they didn't delete account activity, but also whose account activity and what was it? And it's not even. Oh my God. Oh my God. I can't even. Right. Exactly. Yeah. Well, but also you delete it and then you go and view it again. And there's no way they can say it's the same account. I mean, okay, it is the same account to the extent that there's only one account for the entire family. Look at this activity from the same account. If it was only one person on the account, this would be very different. It's the entire family. This is crazy. This is crazy. They may as well be saying his sister did this. Like, this is insane. Ugh. It could have been. It could have been the mom. And that's the thing is whatever was, look, the user, they don't know it's the same person. They have no way to prove that. That would be the best way would be device, and Amazon doesn't have that. So the thing, like I said, right? Like the user, it could be that there's the mom or the dad, and they were embarrassed because they bought some kinky sex shit or whatever, right? And they navigated pages related, and then it could be the same user, it could be a different user. Anybody in the family could be viewing pages associated with the keyboard knife, but there's no connection between A, the deletion of account activity, and B, the K-bar. first of all. Second of all, there's no connection between the user who just simply navigated to these pages and whichever user viewed the other pages. Like, there's no connection to any of this. This is insane. I can't, guys. Y'all, I cannot. Welcome back. Welcome back. They bought Twiz. Right. Thank you. This is what I need to be thinking about. They bought Twiz a blow up doll. Yes. 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 Well, apparently they haven't even interviewed them yet, the family too. So, okay. According to Mr. Howell, far more information must be reviewed in order to attribute specific activity to a person or otherwise render an opinion about, I think I already read this. No, I didn't. User behavior with forensic certainty, including Amazon advertising logs, recommended algorithms, cross-device history, retargeting behavior, account personalization, and device IDs. So this is referencing a device ID, but from before with all the other filings, Amazon said it does not track that. So I don't know. That might be not in Amazon's data, but like Celebrite, maybe? That's what I could foresee being the thing. Defendant is free to challenge this evidence through cross-examination and establish through Mr. Howell why more information is needed to reach the conclusion that defendant made the purchases or clicks. However, it is not a basis for exclusion. There's nothing inherently unfairly prejudicial or misleading. I mean, we're not even there. We're at like, what? I can't even think of an analogy. I can't. Heather, did you come up with something? Dude. It will be up to the jury to consider all the evidence and decide whether defendant was the clicker. I'm going to lose it, but no date. Let's just keep reading so we don't lose it. Defendant relies in part on Idaho Rules of Evidence 106 to exclude the Amazon click evidence. However, that rule is not an exclusionary rule. Rule 106 does not give the opponent the power to prevent the proponent from introducing an incomplete statement. It only gives him the power to require the statement be completed in order or to complete it himself. So this is as it pertains to the completeness, right? Welcome. We have a new squirrel friend, Thanos. Welcome. Also, this sounds very Greek and cool. And what have we got here on your thumbnail thingy, mabobber? U.S. Treasury Financial Crimes Enforcement Network. Interesting. That sounds official. Welcome. I love the very unique and the all caps too, reminiscent of my twin flame Heather. Okay. Thus the motion is denied. Great. Okay, now we're on to the time advance records. Just when we thought we couldn't get any more blow uppy. It's only one account. It's a household account. That's the thing. Guys, have any of y'all had a household account? Because I used to have one, and it was just me and my boyfriend at the time, so just the two of us. But I know exactly what it looks like, and literally, you share all of it. Like you could order something with their credit card. It's like, you know, like on like Netflix, for example, you're like which user, and you can click on it. It's not even like that. It's like literally all one account, as if you're all one person. It's very different than other things where there's not a different profile. It's like literally, like I could have ordered something and had it shipped to like his parents' address, for example, and I could have used like any of his cards on file. And like, it just, you know, of all the things where you can like very easily just, you know, I don't know. I'm gonna have to bump back my Lori Vallow. Inner circle. Since we're still going strong. Oops. Okay. Oh, that's really funny. Yeah, it is 420, isn't it? 420 and Easter. Interesting. Right. And I feel like, didn't she say, though, that they don't have them on their witness list, though? I mean, I'm pretty sure that's what she said. because they were arguing about being able to be in the courtroom and whatnot. And because the rights don't pertain to the defendant, although they should, in my opinion. What is clickbait now? It can't be. So it was all on one credit card then, or whatever payment method, if it can't be switched. Like, okay. So like for me, with having the household account, again, it was just me and my boyfriend, right? But like if you were to go to if you were to like check out and go to pay like credit cards or whatever, it would have like however many cards I've, because sometimes they expire or whatever. So like debit card, credit card, it would have like a 3 or 4, whatever, from under my name. And then it would have like 3 or 4 under his name. And I could click on literally any of them, right, to pay for it. If that makes sense. All right, let's go. The state moves in limine to prohibit the defense from making any reference to the absence of AT&T timing advance records related to the defendant's cell phone. The state contends it never received such records from AT&T in response to its subpoenas, and therefore any statements by the defendant that the records could have or should have been provided to the defendant should not be allowed, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. Yeah, I think she won't put them on the list because of the fact that then they can't be in attendance at the trial. That's because, again, the Idaho doesn't have any case law or provisions for exceptions to the exclusionary rule, rather. The state contends it never received such records from AT&T in response to its subpoenas, and therefore any statements by the defendant that the records could have or should have been provided to the defendant should not be allowed. Just in time, Twiz, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. I think I already read this. My brain is just melted, gone. In support, the state provides certificates of authenticity, AT&T, for each of the 2 warrants, stating that it did not provide timing advance records for the phone number. Let's just pretend that's redacted, because such records were at that time only available if requested within 7 days of the specified time frame. Footnote 9. The homicides occurred on November 13th, 2022. The defendant first became a person of interest on December 19th, 2022. The 2 AT&T warrants were issued on December 23rd, 2022. Thus, TA records for the defendant that could have been of any relevance had long been discarded by AT&T and no longer exist. Defendant, relying largely on the affidavit of its expert, Syray, is adamant that the state did receive the documents, which he argues are exculpatory and is hiding them. Defendant points out he has a constitutional right to challenge evidence against him and therefore must be allowed to explore the state's misrepresentation as to the availability of the records. I was surprised that Ann Taylor was fine with, like, when he was like, fine, you can cross-examine him outside the presence of the jury. And she was like, that will satisfy me or whatever. I was like, why are you satisfied? Like, why? Tell me why. Great question from Need Some Z's. So when Balance denies getting the records, how can Ann go from there? Because in my opinion, he's going to lie. They're going to have something to confront him with. I mean, my thing is like, go to AT&T, right? Like, can't they like, I know the FBI is not going to, say anything, but like AT&T, like whoever it is that he would have been communicating with, I have the feeling that it's probably somebody different from the dudes who were mentioned in the affidavit. I'm wondering if there's another dude, because otherwise I feel like they would have had this already by now to provide. Having said that, also, there was another exhibit filed on April 8th by the defense in support of this motion in limine, but it was sealed. So we don't know what that is. But there was what was it? I think it was an exhibit. Let me just double check. Yeah, it was an exhibit. It was an exhibit in support of the motion in limine with the timing advance, and we don't know what it is because it's sealed. But they did file something else. So there's that. Oh, Joker, welcome. New squirrel friend. Love it. Excellent. I'm trying to read what it says on the thing, but it's too small, guys. It's too small. That's what she said. That's interesting. Max saying he willingly turned over. Right. I mean, that's true. I did find it interesting about the email communications and shit, you know? DB's back. Welcome, welcome, welcome. Right. And that's the thing. That's why I'm saying they need to get to the AT&T person. They need to get to the AT&T person. I'll read what DB is saying here for anyone who's just listening. DB says, I don't think he's going to lie on the stand because there's no way the FBI is going to answer that subpoena. They might just go hide behind TUI again. Like, I'm like, yeah, but we need to bypass the FBI and go straight to AT&T. This just reminds me so much of the freaking DM OnStar data and Murdoch. Like, they need the person who doesn't realize how important they are to like somehow like watch some of the trial and be like, hey, hang on, I have the information you need right here. I don't know, like a miracle. You know, if they don't already have it, right? Couldn't agree more. Mallory saw numbers and just got lost. Yep. Are you talking about Lori Vallow right there? 2021. Right? I know. Boyd Jackson and Steve. You could get Stephen Gordon too. Yeah, Boyd Jackson, Stephen Gordon. Some of those names might pop up on our trivia night tomorrow night, guys, for members only. For anyone who's new, also welcome. Glad to have you guys here as part of the school crew. Feel free to join the Discord. And if you are feeling so inclined, we are having a members only trivia night tomorrow night. Topics will include, where's my list? Famous quotes, first in history, movie trivia, musical theater trivia, trial trivia, and 90s music. So, did he though? I mean, we don't have that much information from him. And Needs Some Z's has been here since the beginning, unlike some people twist. Cough, cough. Yeah, the only way to determine if it's off is from the celebrate. Yes, Needs Some Z's is here from minute one. Oh, were you referencing? Wait, no, you weren't referencing that case because 2021. Well, balance wasn't obviously working on that. Person from those records. Yeah, I can't remember the Boyd Stephen Gordon was a GLDC, right? And Boyd Jackson was, I forget what he did, but anywho, it'll be in the trivia night potentially. And the GLDC is a red herring, as you guys know. That's what I think about that. The thing is, though, is if it's so known that like the only way to get the location database of record is to also get the timing advance, and that's like a known thing. I don't know why that wouldn't have been in the defense filings and or I would say and argued at the hearing, right? Like the thing is this, like any of the things that we all are saying, you know, I don't know that anybody here believes that Ann Taylor is like providing like ineffective assistance of counsel, right? Like she's capable. So like why, if she's not providing it, then what's the deal? You know what I mean? Yeah, so then that could be the dude then, right? That could be the dude. The AT&T connection. Okay. They changed it to like, what is it, 13 months or something like that, I think now. Anyway, all right. Sorry, I can't see where he got it. Right. He did not, Cyray didn't give anything specific about the things. So I don't know. What do you guys think about that? Like, I mean, it seems like maybe it could have been helpful. I don't know. I mean, if Judge Hippler if Judge Hippler had agreed to hear from him, right? I mean, that's the thing, which he didn't because, douchebag. But sorry, that's not respectful of a judge. Let's just say potentially prosecution leaning. How about that? Okay, so defendant points out he has a constitutional right to challenge the evidence against him and therefore must be allowed to explore the state's misrepresentation as to the availability of the records. Okay, the 6th and 14th amendments guarantee a criminal defendant a meaningful opportunity to present a complete defense. This includes the right to confront and effectively cross-examine witnesses. However, these rights are not absolute. The trial court may reasonably limit cross-examination that is harassing, confusing, repetitive, or only marginally relevant. I don't get this at all. I just don't get this at all. I don't get this at all. I don't get this at all. I don't see how this is any of those things. The confrontation clause, and again, I still say, I was surprised that Ann Taylor was like, that will satisfy me. I was like, really? Okay. It was interesting. The confrontation clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. Applying these principles here, the defendant will be allowed to voir dire Special Agent Balance outside the presence of the jury to ask whether he received defendant's TA records covering the early morning hours of November 13th, 2022, and the months prior when defendant was believed to have been in the area of 1122 King Road. However, if Agent Balance denies having received the TA records, defendant may not explore the matter further, either in voir dire or before. Hold on, let me read this again. However, if Agent Balance denies having received the TA records, defendant may not explore the matter further, either in voir dire or before the jury, given the absolute lack of any factual basis supporting his position that the state is hiding them. Footnote 10. Mr. Ray's affidavit, which forms the basis of the defendant's challenge, is replete with speculation and unfounded, and thus highly improper accusations against the state. Further, not once in his affidavit does he address AT&T's 7-day retention period, which fully explains why the state was unable to obtain relevant TA records for the defendant. And that was the one thing where I was like, gosh darn it. Like, I just wish there had been something in there about the 7 days, because that was the whole thing that the state, and Judge Hippler and everybody's, anyway, it's just, okay, we know. Thus, the state's motion is granted except as qualified regarding the very brief voir dire outside the presence of the jury. Haas long, very brief, he says. But I mean, if you impeach him outside the presence of the jury, though, what's he going to do, right? Like, let's just say, and let's just walk through this. Like, let's just say that there's this voir dire outside the presence of the jury, and Ann Taylor impeaches him. What's Judge Hippler going to do? He's already granted the state's motion. I mean, you know what I mean? Like, because normally, like, the impeachment part, right? That's to diminish the credibility of a witness in front of the jury. So without a jury, unless it was a bench trial, then would he? But would he though? But would he? I mean, guys, I just. All right, next we have the self-authentication of records. The state moves in limine to permit the admission of approximately 60 exhibits. Okay. Somebody's not satisfied. To this end, the court will require that after proper notice is given, parties are to meet and confer regarding self-authentication. Oh, right. Yeah, he's like, go figure it out. Okay. I mean, yeah, if in fact there's exculpatory evidence, right, then yeah, for sure, that's different. I guess, impeachment can come in a lot of different forms, right? So, depends on what type of impeachment. Take Jennings out back. Yeah. And that's a good point, right? It's like she didn't have a response to that. It's a good point, AZ, that Hippler asked her multiple times, what evidence do you have? And she did not answer. I agree with that, Needs some Z's. Totally on the same page. Allow questioning in front of the jury at a minimum, right? Depending on the type of impeachment, right? Because again, there's a huge scale there. I think at a minimum, allow questioning in front of the jury. I agree with that. However, he's already granted the state's motion. So, but I guess he could go back on. I guess he could change his ruling. I don't know. It seems like he's left no room for anything to come of that. Like, that's what I'm interpreting. That he didn't leave it open for the possibility that that motion or that voir dire wouldn't be anything more than just like a pat on the head or like a consolation prize. That's what it is. It's like a consolation prize. It's like he's already decided, like he's already granted, like, because there's been other, we've been going through this whole thing. There's been other things where he's reserved ruling, right? He didn't reserve ruling. He's like, the state's motion is granted. Have your voir dire. Enjoy, So I don't know. Okay. Oh, now we're on to the dollhouse. Admissibility of demonstrative evidence. State seeks permission to use a not to scale 3D model of the house as a demonstrative exhibit at trial, contingent on the state laying sufficient foundation to establish the basic accuracy of the model and a demonstration that it will be helpful to explaining the testimony of the presenting witnesses. The state contends the model will aid certain witnesses in describing their testimony. Defendant objects, arguing the state's drawing of the model and other related information. Footnote 11. The other information was the identity and credentials of the person building the model and the data underlying the model. Okay. Was only recently disclosed in discovery in a file that the defendant describes as massive. Massive? How big? How big is it, guys? Hang on.
It's very big.
Defendant claims the data and model cannot reasonably be evaluated by its expert in time. Footnote 12. Defendant submits the declaration of its expert, Matthew Nodal, wherein he discusses that oh, Lord have mercy. Wherein he discusses that it will take at least 3 days to assess the 3D scans recently disclosed by the state, and he will thereafter have to set aside at least 2 days to travel from Seattle to view the model to assess its accuracy. He states he's unavailable until at least April 7th. However, defendant has ample time prior to trial to accomplish these tasks. Defendant disputes that the model is relevant, and even if it was, claims it should be excluded under Idaho Rule of Evidence 403 due to the danger that it might not be accurate. Well, it's not to scale, so it's not accurate. It's not even if it is not accurate. Like, it's just not accurate. Like, why? The trial court has discretion in allowing the admission of demonstrative evidence. I read that as wiggle. What do you guys think? Here, the court finds the demonstrative exhibit is relevant, assuming foundation can be laid because it will supplement the testimony of witnesses. You know that they're going to use this with DM in them, right? I mean, maybe other people, but I would imagine probably that's going to be a thing. Right, because it will supplement the testimony of witness or assist the jury in obtaining a better understanding of the facts in issue. The homicides occurred in 2 bedrooms within a 3-story home with a complicated layout. The suspect's ability to enter the home, carrying out the stabbings, and exit the home consistent with DMs, there it is, observations, will be essential. Why are they even still using, dude, this is just so unnecessary, right? Meanwhile, they used Bryan Kohberger's full phone number earlier. Observations will be a central point of the trial, particularly given the defendant is challenging whether it could be accomplished by one person within the time frame alleged. Yeah, it's down to like, what are we at? Like 6 minutes now or something crazy? It's just like, wow. All right. The model will aid the testimony of lay witnesses and experts alike in explaining the locations of victims, witnesses, and other items of evidence, as well as understanding the suspect's potential or likely path of travel. Moreover, though it is not to scale, accuracy is not the standard governing relevant of this is supposed to say relevance. I'm going to lose it. Relevance of illustrative evidence. Rather, the illustrative evidence must only be relevant to the witness's testimony. Let me read this again and fix it. Though it's not to scale, accuracy is not the standard governing relevance of illustrative evidence. Rather, the illustrative evidence must only be relevant to the witness's testimony. Wow, that's a thing. Okay. Abrogated on other grounds. Okay. So long as the exhibit is not deceptive, it does not have to be shown to be precisely accurate or consistent with the testimony of other witnesses. I just, they were, okay. There was a lot. My biggest thing with this is actually what happened with the back and forth and the weaselness surrounding this, because they were initially going to make it to scale. And then Ann Taylor was like, well, hold on, before you do that, we need our expert to take a look. And so they were like, oh, you're saying you don't want it to scale? Fine, we'll make it not to scale. It's like, no, that is literally, it's like a toddler type of argument. Like, oh, God. It's like, I know you are, what am I? I just can't. Okay. Then we have a footnote here. A forensic artist model of a crime victim's head properly admitted despite discrepancies in size. Shouldn't the head, anyway. The size of the head matters, guys. That's what I say. While defense expert Mr. Nodal contends there is a risk that the state's model could be misleading if it misrepresents the location of a wall or a door or an actual line of sight, those are simply concerns at this point. They're simply concerns? Did he leave a word out? Did he mean to say not? Hold on. Those are simply concerns? Did he mean to say not concerns? The state intends to lay foundation to establish that 3D model fairly depicts the residence, and if it fails to do so, the model will not be allowed. Further, defendant is free to cross-examine the testifying witness and to put on his own evidence, including experts. He may also use his own demonstrative exhibits if proper foundation is laid. However, the state is not going to be held to a standard of precise accuracy in this regard. It will only need to demonstrate accuracy to the point of avoiding deception. One of the things I noted before when we went over these filings with this house is that one thing that's going to be really interesting that I would totally fight over with the state is like the doors, because I would imagine, and I would not be surprised if the state tries to present it with the doors being open and like at the very least unlocked, if not like wide open. Why? Because they're going to try to say how it's possible that somebody could come in and out and do this, right? However, y'all, if you've got a house with all these kids living there, college kids, right? I mean, I just would not believe personally that those doors were not closed. I mean, like if you live alone, you may not close all your doors inside your own house. But if you're living, especially when it's late at night and whatever, I feel like when we see it, the doors are going to be wide open and it's going to be like, no. You know what I mean? In addition, there is no basis under Idaho Rules of Evidence 403 to exclude the model. Defendant contends that allowing the model is prejudicial because it is built from data that was untimely disclosed and which its expert has little time to analyze for accuracy. Footnote 14. Defendant also argues it's prejudicial to the extent it is not accurate, but the court rejects that argument for the same reason it rejects defendant's relevancy argument. While this might be a more compelling issue if the state was seeking to introduce the model as substantive evidence or seeking to have the model accompany the jury during deliberations, it is not. It is simply going to be used. And I am glad it's not going back. Now, the state waffled on that one, or weaseled rather, where they were calling it a demonstrative aid, and then they switched it up to exhibit. I've pointed that out on prior live streams where I'm like, hang on now. Are they trying to sneakadoodle that on in? Because it's very different. Exhibit means they were going to try to get it to go back with the jury, but he's saying it's not going to. We'll see. Who wants to bet that the state's going to try to get this to go back with the jury? How much you want to bet, guys? My money is on they're going to try to get it to go back with the jury. That's Because the state never said they weren't going to. Only Judge Hippler said that, to my recollection. I don't recall the state saying it. The state started out in their first filing trying to say that because they called it a demonstrative aid. But then again, in subsequent filings, they switched it over from aid to exhibit. And I pointed that out because I was like, wait, what? Maybe Judge Hippler didn't catch that. I don't know. Okay. Moreover, as discussed, Mr. Nodal's concerns about his time constraints are based on his impression that he will have to analyze the underlying data to ensure the model's proper scale, dimension, and completeness. Again, accuracy is not the standard. Mr. Nodal need only assure himself the model is not deceptive and that there's sufficient time to do this given the August trial date, footnote 15. Assuming the state can lay sufficient foundation for the model, the court will entertain a request to provide a limiting instruction to the jury that the model is not intended to be accurate and is not to be considered evidence. Entertain a request? Shouldn't this be automatic? To this end, the state is to make the model available to the defendant as soon as it's completed and no later than the pretrial conference the motion is granted. Okay, now we're on to the alibi. Whew, guys. I'm going to push back my Lori stream some more. For anyone who missed it, we've got something really fun in store for you guys at this live stream. Big deal. Okay. Also, in case anyone also missed this, tomorrow night is the members only live stream with trivia night as well. So, okay. Alibi. Here we go. PDSM dungeon. Oh my God. Okay. The state moves to preclude the defendant from offering any evidence in support of an alibi other than from the defendant himself. The basis for the state's motion is defendant's failure to comply with the notice requirements governing alibi evidence. Pursuant to the code, if requested by the state during discovery, a defendant intending to offer an alibi must file a notice listing the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses. We know. Okay. This court has the discretion to exclude testimony of any undisclosed witness offered as to a defendant's absence from, oh God, dude, let me fix this sentence again. Quiz is special. The court has the discretion to exclude testimony of any undisclosed witness offered as to a defendant's absence from, I guess, get rid of the word at, Jesus. Or you could add the word or, from or at, or you need to just get rid of the word at, the crime scene of the offense. Just an alibi is a defense based on the physical impossibility of a defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant time. Hence, in setting forth the notice requirements for an alibi defense, the codes require a defendant to proffer evidence establishing where the defendant's, oh my God, the apostrophe S. This is a mess, y'all. This is a mess. The defendant was at the time of the alleged offense. Evidence only counts as alibi evidence if it proves that the defendant could not have been present at the time of the offense at the time that it was committed. Some case law. At this point, the defendant has only provided notice that he was out driving in the early morning hours of November 13th, 2022 throughout the area south of Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert Syre to partially corroborate his alibi using CSLI data from the defendant's cell phone. However, the alleged offense occurred approximately between 4:07 and 4:20. At most, Mr. Ray can opine as to where the defendant's cell phone was up until 2:54 a.m., where it was apparently turned off, and approximately 4:48 a.m. when it began reporting to a network. Yeah, you can't say apparently. Again, give me the cell bright. Give me the cell bright. It's what I want. It's what I need. Okay. Defendant has provided no evidence as to his location at the time of the crime. In other words, he's provided no alibi evidence as contemplated by the rules. And we have another footnote 16. Okay, this does not preclude the defendant from presenting Mr. Ray's testimony at trial to rebut any contention by the state that defendant's vehicle was seen on surveillance camera driving to Moscow around the same time. Mr. Ray contends he was south of Pullman. However, defendant may not refer to it as an alibi or partial alibi prior to closing. Okay. Interesting. So they can bring it up in closing, guys. That's something. At that time, defendant is instructed to address the issue outside the presence of the jury for guidance on what language related to alibi of any sort may be used. Okay. All right. Well, that's, okay. And then that was footnote 16. That said, the court will not categorically preclude defendant at this point from offering alibi evidence at trial. There are still 4 months until trial begins. If defendant does unearth alibi evidence, it is his obligation to immediately make the state and the court aware of it. At that point, the court can apply the Juarez standard. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised if the defendant does disclose alibi evidence. However, at this point, the defendant has not provided an alibi, partial or otherwise. Okay, prior traffic stop. Both sides encouraged Judge Hippler to watch the video. Did he watch it? Let's find out together. Okay, speeding and issued a citation for failing to wear a seatbelt. Specifically, the state seeks to admit the officer's body cam footage of the traffic stop as well as the citation, arguing it is relevant to proving the defendant's identity, vehicle, ownership, and control, address, and phone number. Footnote 17. The judge previously presiding over this case analyzed the admissibility of the footage in the context of the grand jury proceeding and found it admissible. Specifically, the judge found it relevant to identity and was not otherwise barred by Idaho Rule of Evidence 403. I love you, Judge. I hope you're doing good and hope you're happy. Hope you had a great Easter and a great 420. Okay, defendant objects, pointing to Idaho Supreme Court case law stating that evidence of prior misconduct is relevant on the issue of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct and the charged crime. So I can already see where this is going because, again, apparently this has like nothing to do with the charged crime. But you can, yeah. Anyway, confusingly, defendant argues his prior, literally keep reading, argues his prior traffic stop bears no resemblance to the charged crimes and therefore cannot be relevant to identity. He also argues it is unfairly prejudicial and may confuse the issues. Evidence of other crimes, wrongs, or acts may not be admitted pursuant to the rules when its probative value is entirely dependent upon its tendency to demonstrate the defendant's propensity to engage in such behavior. I still feel like this has to be more than just not wearing a seatbelt or speeding. I just cannot, for the life of me, believe that is what this is about. I still think there's something weird on that passenger seat. We'll find out, maybe. To determine the admissibility of evidence under Rule 404B, court must find the evidence is sufficiently established as fact, footnote 18. There is no dispute that the evidence is sufficiently established as fact, thus the court need not make a specific articulation on the matter, okay? And relevant as a matter of law, to a material and disputed issue. It's not a K-bar because it has nothing to do with the crimes as charged. Okay, twas. Literally. They said it is something that they thought the jury could the words they used were like wrongful behavior, which I found especially interesting. And that's why I was like, is it like gay porn? Like they said, it's not connected to the crimes. It's not something that is even illegal or can even be given a citation for it. The things that they're talking about are like wrongful behavior and they don't want the jury to judge them. That's what it said. You better believe a K-bar knife would not meet that criteria as described by the defense. And relevant as a matter of law to a material and disputed issue other than the character or criminal propensity. It must then conduct a Rule 403 analysis. The court finds the evidence is relevant to establish defendant's identity and link him to the charged crimes. Indeed, the citation body cam footage up to the point that the defendant provides his phone number, footnote 19, just prior to the defendant providing his phone number, he asked the officer why he needed it. This is after the defendant provides his phone number. He and the officer discuss ancillary matters that in no way bear on the defendant's identity. Thus, this portion of the body cam shall be redacted. And I did find it fair, his suggestion of redacting it. I think that is probably the best way to go about this. The evidence also establishes defendant as the registered owner and driver of the vehicle, make and model of which was thought to be used by killer. Further, the evidence places defendant in Moscow at night on one of the dates of interest alleged by the state to be relevant to planning the charged crime. All of these factors played a role in the investigation of the crime. What investigation? Footnote 20. Case law supports the use of identity evidence. Okay. Identity evidence. Okay, I'm not going to read all that. I mean, we get it. While defendant cites to the case law discussing identity under Idaho rules of evidence as requiring strong similarities between the bad act and the charged crime, this is in the context of establishing identity through a signature quality or modus operandi. MO. Right. Okay. And then we have a footnote 21. So this case advises judges to distinguish between the MO exception for proving identity under the rules and other methods of proving identity, so that they don't impose the strict standards of proof of modus operandi. Operandi. Why am I forgetting how to pronounce this? Operandi. Oh my God. MO exception on other methods of proving identity. Where did that footnote go? There it is. State, however, is not seeking to introduce the traffic stop to establish an MO. Therefore, defendant's case law and argument is not well placed. Upon weighing the Idaho Rule of Evidence 403 factors, the only portion of the body cam footage the court finds troubling is when the defendant inquires why the officer needs his phone number. This inquiry could be perceived by jurors to be insolent. Given its lack of relevance and potential for prejudice, the inquiry shall be redacted. Other than this redaction, there's no basis for further exclusion. Defendant's claims of unfair prejudice and jury confusion lack merit. 100%. And it has a relation to the crime. There's no way it's a KUR. No way. No way. Absolutely no way. They made it very clear. We read that and we looked at it and we broke it down word by word. And it's like, what are they referencing here? I mean, somebody even suggested a shower curtain. I was like, no way. Literally no way. It's something that, in my view, it seems like it's morally a problem for some jurors, potentially, but is like not related to the crime and it's not illegal and da da da. Right? Okay, that was my thought. Anyway, first he argues there is no nexus between the traffic stop and the charged crimes. Thus, the jury may consider it as propensity evidence or otherwise be confused. However, as discussed, right, exactly, right. I mean, it would be illegal, but it will also be related to these crimes, obviously, right? Thus, as far as what the state's alleging, right? State may consider it as propensity evidence or otherwise be confused. I mean, I will just say, if there was any type of knife, right, that would still could be construed as related to the crimes as charged, right? So anyway. Okay, however, as discussed, a nexus is not required for the purpose advanced by the state. Moreover, unfair prejudice arises only when the evidence has an undue tendency to suggest a decision on an improper basis and appeals to the jurors' sympathies, arouses their sense of horror, provokes their instinct to punish, or otherwise causes the jury to base its decision on something other than the established propositions in the case. I'm going to read this again, speaking of. Arouses their sense of horror, provokes their instinct to punish, or otherwise causes a jury to base its decision on something other than the established propositions in the case. A traffic stop, particularly one as minor as this, is not the type of evidence that will compel a jury to conclude the defendant is guilty of murder because of violated traffic laws. Couldn't agree more. I feel like there's got to be something more to this. Further, the court will provide a limiting instruction. I mean, illegal or not, any type of knife would be considered to have a link to this case, right? Like the state would see that as a link. And the defense was very clear. Okay. Defendant also contends it is unfairly prejudicial because the body cam footage provides a clear shot of the defendant's vehicle, which may lead the jury to believe it is the suspect vehicle captured on surveillance videos at and near the crime scene. However, that is precisely what evidence makes the evidence. However, this is precisely what makes the evidence probative. It links the defendant to the crime scene. While this may be damaging to the defense, it is not unfairly prejudicial when balanced against its strong relevance. Footnote 2. Defendant also noted at the hearing that the traffic stop occurred on the same day that Agent Balance determined through CSLI analysis that defense cell phone was using resources consistent with being in the area of 1122. King Road. Defendant did not, however, articulate how this correspondence was unfairly prejudicial, nor does the court find it to be so. Okay, there's that footnote. Thus, the motion is granted with the noted redactions. Okay, one down, guys. And up next, vehicle. All right. In the early morning hours of November 13th, 2022, surveillance videos from various locations near the crime scene picked up footage of what law enforcement believed to be, the wording here is going to drive me insane. Oh, it's just sad. what law enforcement believed to be the same vehicle. I mean, this almost sounds like conceding that they were wrong. Like they believed it to be the case and then they learned they were wrong. That's what this sounds like to me. Sounds like a concession. Footage of what law enforcement believed to be the same vehicle as suspect vehicle 1. Wow. The white sedan that was seen arrive. I think this is supposed to say arriving. Oh, sorry. No, maybe not. Arrive at and then depart. No, this one he didn't get wrong. Okay. Arrive at and then depart from the area of the house at the time of the homicides. From one such video, law enforcement determined the vehicle was a 2011 and 2016 Hyundai Elantra. Notably, of course, it's with the expanded year range. Defendant seeks an order precluding the state from referring to the vehicles depicted on the various surveillance videos as the same vehicle, and from asserting that suspect vehicle 1 is a 2014 and 2016 Hyundai Elantra. He argues that these are speculative conclusions that invade the province of the jury. The state responds that it intends to elicit expert testimony establishing the vehicles are the same. Good luck with that. And such testimony will be neither speculative nor otherwise improper. Oral argument on the motion was held on April 9th, after which the court took the matter under advisement. The court finds that the state may present expert opinion that the vehicles depicted in the videos are the same vehicle as suspect vehicle 1, as well as the make and model thereof. The admissibility of expert testimony is discretionary. The trial court must 1, correctly perceive the issue as one of discretion, 2, act within the boundaries of such discretion, and 3, act consistently with any legal standards applicable to the specific choices before it, and 4, reach its decision by an exercise of reason. Facts. Following the homicides, law enforcement gathered video surveillance from various locations surrounding the crime scene, including 112 King, a residence immediately to the northwest of the crime scene. That video footage showed a white sedan, suspect vehicle 1, enter the King Road neighborhood at 4:04 and then depart from that area at a high rate of speed at 4:20. The same footage showed what law enforcement believed to be the same vehicle. Again, the same type of languaging here. Interesting. Believed to be the same vehicle make 3 initial passes by the crime scene in the 30 minutes before its 4:04 a.m. entry. Surveillance videos from 5 other locations within 0.6 miles of the crime scene also captured what law enforcement believed to be suspect vehicle 1 in the hour preceding the crime. Footnote 1. Oh, okay, fine. Based on the direction of travel and timestamps from these videos, investigators mapped what they believed to be suspect vehicle 1's route of travel. And these footnotes, I'm just going to show you all. It's just referencing exhibits, so I'm not going to keep scrolling down. One of the surveillance videos relied upon by law enforcement was from a camera located at 1125 Ridge Road. Video footage captured at 4:01 a.m. from this camera provided a clear view of the white sedan depicted therein, which law enforcement believed shared similar class characteristics to a 2014 and 2016 Hyundai Elantra. While there is no continuous footage showing the vehicle identified in the Ridge Road footage traveling to the crime scene, the Ridge Road camera was located 0.3 miles down the road from the crime scene. From this collective evidence, investigators believed the vehicle seen on the Ridge Road footage at 4:01 a.m. was suspect vehicle 1 captured on the 1112 King Road footage at 4:04 a.m. Analysis. Based on the lack of continuous footage showing the vehicles captured in the various videos traveling to the crime scene at 4:04 a.m., defendant argues it would be improper for the state to identify those vehicles as suspect vehicle 1 or otherwise identify suspect vehicle 1 as a 2014, 2016 Hyundai Elantra. He argues any such testimony is speculative and therefore not relevant, unfairly prejudicial, and invades the province of the jury. The state responds that the testimony is based on logical, educated inferences drawn by law enforcement from the surveillance videos. It adds that the testimony does not invade the province of the jury. It is highly relevant to determine whether the vehicle captured at 4:04 a.m. on the 1112 King Road camera was the defendant's vehicle. To the extent that the defendant is attempting to prohibit the state from arguing or asserting as fact that the vehicles are the same or that the suspect vehicle 1 is a 2014 to 2016 Elantra, he is correct that it would be speculative and improper without expert testimony to provide a basis to make this contention. However, this prescription does not prevent the state from eliciting such opinions from law enforcement and asserting this as an allegation during the trial based on that testimony. An opinion is speculative when it, quote, theorizes about a matter as to which evidence is not sufficient for certain knowledge. and suggests only possibilities. Here, law enforcement's opinion that the vehicle captured on the Ridge Road camera at 4:01 a.m. is suspect vehicle 1, captured at 4:04 a.m. on the King Road 1112 King Road footage is not based on unsupported theories or possibilities. Rather, the opinion is based on the investigators' training and experience and educated inferences drawn from their review of surveillance footage from 6 locations within a mile of the crime scene during the hour preceding the crime. I mean, I just don't see how any juror is going to look at these pictures and videos and whatnot with the quality that they are and think that any reasonable person can identify shit about the vehicle for, like, really, other than it's like not a truck, right? Like, really, it's like, you've got to be kidding me. From this evidence, the investigators were able to map what they believed was the suspect vehicle's route of travel preceding the crime, as well as identify its make and model. Defendant ignores this collection of evidence and focuses instead on solely 2 points of reference. However, the investigators had multiple data points. So what they're saying is that the opinions would not usurp the jury's role as fact finder. The jury is tasked with determining whether the defendant committed the alleged crimes. The state asserts that the perpetrator drove suspect vehicle 1. And based on the totality of the evidence that it was defendant's Hyundai Elantra, the jury is free to weigh this evidence and the investigator's testimony against that offered by the defendant and decide for itself what the surveillance videos depict and whether it supports its ultimate conclusion bearing on the defendant's guilt. Yeah, if I was shown those, if I was on a jury and I saw that shit, I'd be like, you've got to be kidding me. You tried, like, what? What are we doing? Finally, defendant's only articulated basis for excluding the testimony is that it would be prejudicial due to its speculative nature. Because the court has found otherwise, there is no basis for its exclusion under the rules, and as its relevance is substantially outweighed by the factors with which Rule 403 is concerned. Based on the foregoing, it's denied. Okay, next up. Bushy eyebrows, guys. Bushy eyebrows. By the way, for those of you guys who are members, we do have a custom emoji of Dylan's math drawing. It is literally the math drawing. I had to invert it so that it's black and white flipped because no one could see it, but it's literally her drawing. All I did was I just switched the colors. So feel free to check that out, those of you guys who are members, and relevant here for sure. All right. DM, really, we're still using that. Okay. Roommate of the victims in this case was the sole eyewitness to the sole eyebrow. Sorry. To the intruder believed to have carried out the homicides at 1122 King. During her interviews with law enforcement and at the preliminary hearing, DM described the intruder as having, oh my God, I fixed it. It says at, I automatically said as. What it says here is DM described the intruder as having bushy eyebrows. Defendant moves in limine to exclude any evidence at trial referencing the bushy eyebrows, arguing the description is unreliable and therefore irrelevant. Oral argument on the motion was held. Right. He determined it was admissible. Welcome, Leslie and Billy. Standard. The question of whether evidence is relevant one of law. They left out another is one of law. My God. While the decision to admit relevant evidence is discretionary. On discretionary matters, trial court must 1, correctly perceive the issue as one of discretion, 2, act within the outer boundaries of its discretion, and 3, act consistently with the legal standards applicable to the specific choices available to it. And 4, reach its decision by the exercise of reason. Oh yeah, he already put those in an earlier filing here. Facts. On November 13th, sometime before 4:19 a.m. Oh boy. DM observed a person inside her residence, which she shared with her 4 roommates. At 1122 King. DM placed several phone calls and sent several text messages to her roommates. The only roommate who responded was BF, who resided in a downstairs bedroom. They had 2 short phone conversations and exchanged texts. Within those phone calls and text messages, DM relayed to BF she saw a person in the residence wearing black, and he had on a ski mask that covered his forehead and mouth. That same day at approximately 11:56 a.m., a 911 call was placed from 1122 King Road for a reported unresponsive female. The unresponsive thing. Okay, keep reading. Moscow Police Department responded to the scene, and Officer Nunez took a statement from DM. She told Officer Nunez that she saw a male, not insanely tall, wearing all black. I mean, we know all of this, right? I'm not going to, like, literally, we've read this so much. So much. I feel like we probably all have it memorized. Introduced taller than her, basketball player, kind of skinny, a voice she did not recognize. Yep, yep, yep. She said she was kind of in and out of it because she was so scared and really, really tired. She did not mention anything during that interview about the intruder's eyebrows. At approximately 1:47 p.m. that same day, DM was interviewed by Mallory, the Idaho lolly. During this interview, DM reported she saw a white male she did not know, and then this is where she's going to add in the eyebrows. Regarding his height, she reported, I'm 5'10", so he's probably around 6 feet. She responded no when asked if she saw what color his eyebrows were and added, I don't remember what his eyes looked like either, but she saw his eyes and he was definitely a white guy. She again mentioned she was in and out of it because she was tired and explained everything was kind of blurry. I just don't fully remember it, I would say. Sounds like a great witness. 4 days later, she was interviewed by Idaho State Police Detective Victoria Gooch. Gave a detailed recounting of what she did on Saturday and until she went to bed. Went to bed at approximately 3:20 a.m. She stated that sometime between 4 a.m. and 4:20, she woke up and heard a male's voice. It's okay, I'm going to help you. Again, we know all this, but here we go. I'm probably still tipsy, and I believe I was also very drunk. Great. And then all this we've read. This is where the bushy eyebrows come in. Okay. I was probably still a bit drunk. Great. DM then recounted calling and texting her roommate BF that there was someone in the house wearing all black and a ski mask. DM conveyed to the interviewers that she did not know for sure if it fully happened. I don't know if my mind's like making up stuff. Oh my God. It just doesn't make sense to me. I don't know how to fully explain it, I guess. This is why I've said if I were on this defense counsel, I would totally make this witness my friend and I would approach it from that matter because I think that would be a good strategy here. Be the good guy, make the state the bad guy. Because she's not going to want to be on that stand, guarantee you. DM also agreed that she was traumatized and it could affect her memory. Detective Gooch also asked DM if she suffered from anxiety. DM responded that she did and that she had a lot of lucid dreams of like being kidnapped or chased. Great. She also indicated she would watch Criminal Minds and fall asleep to crime podcasts. I mean, just like, yeah, good point. Tipsy and drunk, right? Yeah. How does one manage that? Detective Gooch and Captain Blaker then sought to reconfirm the facts from DM's memory. DM reiterated that she saw a male figure in the hallway. He was holding something. He was wearing all black clothes. His forehead was covered. He was wearing a mask. She remembered his eyebrows. I don't know, weird looking ski mask. It wasn't like a regular ski mask with like eyes. And, because I saw his eyebrows and I think I saw his nose and like this part of his face, but I don't know. She stated she could not see the male's mouth and did not remember if she saw his nose, but confirmed, I know I saw eyebrows. I don't remember his eyes. But like, and there's no point. There's just no point. I was going to point out a contradiction, but there's just no point. There's just no point. I just feel like I can see eyebrows, but I mean, that could be it. I mean, that would make sense why his forehead was covered and this part of his face was covered. I mean, this looks like to me somebody who is like, doesn't like, dude, best case scenario, right? Like drunk, tired. Like she's literally telling them, look, don't rely on me for this. And this is just so reminiscent to me of how false confessions happen, right? Where they keep pressuring you. And over time, we see more things appear, right? From somebody who's like literally telling them, like, look, I am the least reliable witness of all time. Like literally. And they're like, we need you. That's my take on this. It will be brutal. And that's why, like I said, if I was Ann Taylor or Miss Massoff, I would approach it of like being, again, like the good guy. I think you will get more answers that way. Okay, so the investigators inquired if DM could provide a composite for an artist, but she said she could not. Again, she reiterated she did not remember what his eyes looked like. I don't remember what his nose looked like. I just remember eyebrows. I just don't know exactly what the eyebrows looked like at all, really. I just remember thinking like eyebrows. Yeah, bushy. But that's all. Like, I don't remember the shape. I don't remember like the color. I just remember like bushy eyebrows. That's the only thing I can remember. Oh my God. Okay. Then on the 13th and 19th, law enforcement took photos of DM's bedroom. On the wall, there were many magazine photos and drawn pictures pinned to cork boards. The drawings were of human faces with an emphasis on eyes and eyebrows. Some of the eyebrows are heavy. We can do that. I mean, we need a specific city. What's a city in Arkansas? Little Rock. Nightbot's got you back. On December 1st, DM was interviewed by forensic interviewer Erin Williamson. DM gave a detailed accounting of her day on Saturday, November 12th, until she went to bed on Sunday. And then again, heard a man's voice. It wasn't Ethan's. It was like, okay, I'm going to help you. Again, all this, similar here. I don't remember if it was just like one eyebrow or two, but it was just like this bushy eyebrow. She described she described texting BF about a guy in all black and described the ski mask, stating, I couldn't see any of his hair, but I just remember seeing like it was almost rectangular. Again, I'm just not going to even. And this, I think, is supposed to say across, like all one word. Welcome, Toes. I just remember it being bushy. I just remember. And then here's that part, right? Okay, from what I remember, I think he was just like walking past that little wall and going towards the kitchen. And I don't know. Like, I just remember seeing an eyebrow. I just don't know why I see just one. It was like one bushy eyebrow. Wow. Doof. Yeah, like the full shape. I just remember being bushy. Wonderful. DM drew the mask for the interviewer. Did she now? While drawing, she gave a consistent description of the mask and noted the eyebrows. I don't remember if I saw one or two. Like, it was just weird. Yeah, it's really interesting how many times she mentions the number discrepancy. She explained that she had scary lucid dreams, but that she would always know she was dreaming. Well, then that doesn't really count as a lucid dream. When she saw the intruder, however, she did not fully understand whether it was a dream or not. Well, she also indicated when she first saw the intruder, she thought he might be a fireman. Great. On December 29th, the defendant was arrested in Albertsville, Pennsylvania. Yeah, that's not, yeah. The following day, on December 30th, DM was interviewed by Idaho State Police detectives. They asked her whether she'd seen a picture of the defendant. She stated that she had seen the mugshot, but had no clue whether the defendant was the person she saw in her house. She explained, from what I remember, I just remember seeing this figure that was like not fat, obviously more skinnier. Are we a basketball player? Are we a fireman? What are we doing here? I just don't know what the mask exactly was. When I thought about it, it was like covering here and here. I just Again, a lot of this is redundant. And then, and this knowing there's like, I knew he had looked at me because of the bushy eyebrow. That's all I remember, but I have no idea what he looked like. I don't like, when I looked at his picture, nothing came back to me at all. So that, like, I don't know. I feel like if I saw that, my mind would be like, oh yeah, that's him. But it's just, I don't remember it all. I think this is great testimony for the defense. She literally says, if I saw that, my mind would be like, yeah, that's him. And she can't identify him. Who's begging now? When asked whether she told BF the male had a big nose, she said, all I remember, I don't remember big nose at all. I think we're clear on this. Like, what, if anything, does DM know? One, maybe two bushy eyebrows. That's the best case scenario. Right. Didn't recognize the picture. Correct. Correct. I mean, and again, it's even more interesting that she literally says, prefaces it by saying, I would recognize them if I could. Like, she literally says that and then follows it with, I don't recognize them. So that's why I said, like, it's great. I think that's actually great for the defense. Okay, now so she's like, it wasn't like one of those circle ski masks. That's all I remember. And then she testified at the grand jury. She woke up around 4 a.m. to noises. She testified she opened her door and heard a man's voice say, it's okay, I'm going to help you. And I didn't know who the man's voice was. She testified she opened her door again and saw a figure in all black, which I believe was a person. I forgot about this part. Oh, it just gets worse. Was it a wildcat? Was it a wildcat? Any of you guys have been following the Murdaugh, revisiting the trial testimony, or even followed it before, you guys might know what I'm referencing here, the shape-shifting wildcat/person. I knew the person was white, but you didn't even know it was a person, which I believe was a person. I knew the person was white. Okay. I don't know how, but I just knew it. Knew it was male. I think I knew that because of the voice. Ugh. The person was around my height or a few inches taller. Dude. Here we go back with the basketball. I dreamed I was skiing all night. That's hilarious. Regarding what the person was wearing, she testified, there was like, from what I think I remember, it was like, now it's I think I remember. It's like a black mask, almost like a ski mask, but not. It like covered the head, maybe up to the mouth, maybe more. I can't remember if it covered just the chin, the mouth, or the nose, or lower. Oh my God. Well, the one thing I can really remember was something about a bushy eyebrow. I don't remember seeing anything else, just something about a bushy eyebrow. Wow. Defendant first suggests that DM is not competent and or lacks personal knowledge to testify about bushy eyebrows, because her testimony is not reliable under the Mason-Biggers balancing test, a test that is applied when determining whether witness identification is reliable or whether it was the product of police suggestiveness. Defendant argues DM's description of the physical characteristics of the intruder were general in nature and could fit millions of individuals. Defendant also notes that while he does not have bushy eyebrows, the artwork on her wall displays individuals with prominent eyebrows. As the state notes, however, the Mason-Biggers test does not apply here because DM did not make an identification of the defendant, and her descriptions were not the result of the use of law enforcement identification techniques. In fact, the sole instance when DM was asked to identify the defendant was when she was shown his mugshot after the arrest. She responded she had no clue whether it was the person she saw. Not to be deterred. Ooh, that's rude. Not to be deterred. Wow. Yikes. I don't like that at all. Yeah. That gives me the heebie-jeebies. Defendant alternatively argues that the court should find DM unreliable based on scientific studies that explain the fragility and inaccuracy of memory. Like, just so rude. Like, I can't even. The court finds no basis to do so, footnote 3. And he's just freaking citing this test again. As a general matter, every person is competent to be a witness. Really? Incompetency, which is determined by the court, applies to persons whom the court finds are incapable of receiving just impressions of the facts about which they are examined or of relating them accurately. Additionally, a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. DM was a direct witness in this case. Well, as the factual recitation sets forth in detail, DM's account of what she saw and the physical characteristics of the intruder were remarkably consistent throughout all 5 interviews and her grand jury. While she did not mention his eyebrows in her initial interview, she thereafter identified the bushy eyebrows. Well, what about the problem with the 1 or the 2, right? Are we going to leave that out? See, it's plural here. He's got it plural. Bushy eyebrows on multiple occasions as something that firmly stuck out in her mind. Although she might have been intoxicated or tired or questioned her memory, the consistency of her descriptions suggests a high degree of reliability. How can you say this, though, with a straight face? For real. Like, how? While defendant may cross-examine DM about his concerns with her memory, his challenges to her competency and personal knowledge as a basis for exclusion are unfounded. There's no basis under Idaho Rules of Evidence 403 to exclude the testimony. Defendant next asserts that DM's testimony about bushy eyebrows must be excluded under the rules, which permits exclusion of relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues. Okay, we're not going to read all this. We already know the rule. He asserts that to allow her to testify about bushy eyebrows would confuse the issues and result in unfair prejudice because of the danger the jury will believe he is guilty due to his eyebrows. However, DM's testimony about bushy eyebrows is highly relevant in this case. DM is the only eyewitness to the intruder responsible for the homicides. It is the jury's task to determine whether the defendant is that person. Further, there's nothing confusing about her testimony. How can you write this? Like, literally, just don't know. Her descriptions of the bushy eyebrows. What about the one eyebrow, though, dude? Have been consistent and clear. No, incorrect. While she could not provide enough details for a composite sketch, it is unsurprising given her observation that the intruder was wearing a mask on his face. Moreover, while this description might or might not implicate the defendant, it will not result in unfair prejudice. Unfair prejudice arises only when the evidence has an undue tendency to suggest a decision on an improper basis and appeals to the jurors' sympathies, arouses their sense of horror. Okay, back to this one again with the arousing of the horror. Okay, DM's description of the intruder having bushy eyebrows will not reasonably compel a jury to find the defendant guilty simply because he may have similar eyebrows. What about one eyebrow? There's a large gulf between that is interesting. There's over 20 cities named that's interesting. There's a large gulf between a finding that a witness is not competent to testify about what they personally witnessed and simply allowing impeachment by vigorous cross-examination. I mean, again, right? Impeachment by vigorous cross-examination. He means in front of a jury, right? Thinking back to balance there. This is a matter for cross-examination by the defendant and any concerns with DM's ability to perceive and remember what she claims she saw may be tested in that manner. Oh my God, Bert and Ernie. The order is denied. There you go, guys. Okay. Can we try to, what is the word I'm looking for? Can we get through this one as well? Let's see. All right. I don't know. I feel like I might want to save this for another live stream because I feel like this is going to be quite dense. I might want to save this. Plus, I have rescheduled the Lori Vallow stream a bazillion times. I think I'm going to save this one. And that means that that'll work out because honestly, it'll be this and then the DNA, the touch DNA. We'll do those two. That's what we'll do. Who has a problem? DM. I'm just trying to see what y'all are talking about here. Meg P. Rage quit. What does that mean? What are y'all talking about? Well, but again, there's no actual Lori. There's no actual Lori. It's Lori's inner circle. We're going to be looking. I've got a big surprise for you guys on this one. It's Chad, Julie Rowe, and like Melanie Gibb. So Lori's not even going to be involved. Welcome, Victorine. Oh, sounds on. Okay, gotcha. Okay, gotcha. Yeah, I know you're sick of Lori. I have a big surprise though for this one. So I'm super excited. So we'll save this one for when we cover the other order here, again, dealing with the touch and contact DNA. But for now, we're going to shuttle right on over via the portal we're staying in no, we're not staying in Idaho. Sorry. We're kind of going to Arizona, kind of, not really. Actually, we're kind of going to Utah, I should say, given the surprise I have for you guys. All right. So with that, thanks for being here, guys. Love y'all. We will continue onward as always with these. And until then, love y'all. And I'm going to go ahead and roll that outro. See y'all on the other side.